Also with us, Stephanie Rawlings-Blake, former defense attorney, and Page Pate, a criminal defense and constitutional law attorney, also with us this morning. As we look at, where we stand in terms of this evidence and what the judge ruled this morning, I'm just curious. First of all, your take on that, Page, and what that could mean.
I think that the judge made the correct call. I mean, it's not about character. It's definitely about motive. It's clear that the defense took a hard blow. They're trying to erase any notion that their clients acted out of malice, acted out of racism. And between the inclusion of the tape as well as the Confederate license tag, that's definitely a big hit for them.
Page Pate with us now. And Page, the jury breakdown has attracted a lot of attention because here you have Brunswick, Georgia, which is 55% black, Lynn County, 26% black, yet there's only one of 12 black on an otherwise all-white jury. In your experience, does that impact jury decisions, right? I mean, it's clearly not reflective, but in your experience, has that been found through data to affect decisions?
Well, I think it certainly can, Jim, especially in a case like this where race is going to play such a big part, not just in the evidence that's presented to the jury, but also in the arguments that the lawyers will make during the course of the trial and at the end of the trial. You are absolutely correct to point out that this jury is not reflective of the population of Glenn County. It is not even reflective of the people that were found qualified to serve in the case. So after 2.5 weeks of jury selection, they were left with about 25% African Americans in the pool, and then all but one of those were struck. So this is a very different jury for Glenn County, and it's going to be interesting to see how this plays out.
It's certainly, I mean, that fact alone is certainly getting a lot of attention nationwide, and those are the headlines we're seeing, right? It is really about the makeup of this jury and what that could mean. Stephanie, as we look at what we're expecting to hear from the defense, I found this interesting, this sort of two-part defense that they're expecting to lay out. So, number one, this was a citizen's arrest, but it was also self-defense, and yet there's this video that shows Ahmaud Arbery, who appears to run around the truck, but then runs into Travis McMichael. So, as you're looking at that, the video almost seems to in some ways contradict that argument. How do you envision the defense putting that together?
I think the defense is going to have a tough time putting it together. They have a hard case. These individuals, as the prosecutor laid out, don't own the property, weren't instructed to protect the property, yet they took it upon themselves to act as the police. So I think it's going to be tough for the defense to put those things together and lay out a credible case that will convince at least one juror that this was a self-defense.
Paige, I mean, what are the rules around supposedly making citizens arrests here? I mean, by the way, armed against someone who was not armed.
Jim, there are no rules in Georgia law, and certainly not at the time, about whether you could be armed or not armed. The law, as we all know, has since been repealed in Georgia as a result of this case. But back last year when this incident occurred, it was okay under Georgia law if you either saw someone or had good reason to believe someone had just committed a serious offense to try to track them down and then hold them for law enforcement. So it is a two-step question here for the defense. Can they convince the jury this was a legitimate citizen's arrest? And two, when they confronted Ahmaud Arbery, did they have a legitimate claim of self-defense? It's a big challenge.
Yeah. Interesting that law has been repealed since. Stephanie Rawlings-Blake, Page Pate, thanks so much to both of you.
Thank you.